They invoked appraisal. Only one of these invocations was actually about the money. NAPAICC Insider Research Desk, Tampa Bay, Florida. 3 homeowners each received notice that their carrier was invoking the appraisal clause, but a claim-by-claim review finds only one of the 3 invocations was actually a straightforward valuation dispute. The findings illustrate why an appraisal demand by itself tells you almost nothing, and why the same 3 words, invoked appraisal, can describe 3 unrelated situations. Key takeaways. 1. Appraisal is a policy mechanism for resolving disputes over the amount of a loss. It is not by itself evidence of bad faith. It exists specifically for cases like this. 2. The most common misuse isn't a rigged number. It's a carrier attempting to route a coverage dispute, which appraisal cannot resolve through a process meant only for valuation disputes. 3. A genuine process problem traces back to specific identifiable defects, a compromised appraiser or umpire selection, not simply a valuation outcome the homeowner dislikes. 4. In all 3 cases reviewed, the correct response depended entirely on which of these 3 conditions was actually present. Claim 1. The genuine valuation gap. Appraisal working as intended. Loss type, wind and hail, full roof and siding replacement. Carrier estimate, $61,000. Homeowner's estimate, $104,000. Outcome, resolved through appraisal at $89,500. A homeowner and her carrier agreed the loss was covered. A wind and hail event had damaged the roof and siding. What they could not agree on was the dollar amount required to repair it, with a $43,000 gap between the 2 estimates that neither side's adjuster or contractor could close through negotiation. I heard appraisal and assumed it meant they were trying to get out of paying. A homeowner in a comparable claim. A review of the policy language confirmed the appraisal clause exists precisely for this scenario. A genuine good faith disagreement over the amount of a loss that both parties agree is covered. Each side selected an independent appraiser. The 2 appraisers selected a neutral umpire, and the panel reviewed both estimates in detail before reaching a binding figure. Diagnosis: appraisal used as intended. A legitimate valuation dispute resolved by its designated process. The panel's figure, $89,500, fell between the 2 original estimates and was paid within the policy's standard timeline following the award. The lesson: appraisal existing and being invoked is not itself a red flag. It is the process the policy provides for exactly this disagreement. Claim 2. The coverage question disguised as a valuation dispute. Loss type, water damage, cause of loss disputed. Carrier action, appraisal invoked in lieu of a coverage decision. Outcome, appraisal challenged and coverage question returned to the claims process. A second homeowner's water damage claim had not yet been accepted or denied. The carrier's position was that it needed to determine whether the loss resulted from a sudden pipe failure, which was covered, or long-term seepage, which was excluded. Rather than making that determination, the carrier invoked the appraisal clause and proposed proceeding directly to a panel. A review of the policy and the correspondence found that appraisal by its own terms resolves disagreements over the amount of a covered loss. It does not have authority to decide whether a loss is covered in the first place. Inviting a panel to value a loss whose covered status hadn't been established would have required the appraisers to decide a coverage question they had no authority to rule on. Diagnosis: a coverage dispute misrouted as a valuation dispute. Appraisal was invoked before the threshold coverage question had been resolved. A written objection, citing the specific policy language limiting appraisal to the amount of loss, resulted in the carrier withdrawing the appraisal demand and issuing a coverage determination instead. The lesson: appraisal answers how much. It has no authority to answer whether. When the second question hasn't been settled, an appraisal invocation is premature, not routine. Claim 3, the compromised panel, a genuine process problem. Loss type, fire damage, full structure. Carrier action, umpire selected with an undisclosed, ongoing business relationship with the carrier. Outcome, panel selection challenged in court. A third homeowner's claim proceeded to appraisal on a straightforward valuation dispute, a scenario similar to Claim 1. The problem surfaced during selection of the neutral umpire, the third panel member responsible for resolving disagreements between the two-party selected appraisers. The umpire's name kept coming up. He'd worked the carrier's appraisals for years. Claim summary, claim autopsy research notes. A review of public filings found the proposed umpire had served as an appraiser or umpire on a substantial number of the same carrier's prior appraisals, a relationship not disclosed at the time of selection. Most states require umpires to be disinterested, and a pattern of repeat selection by one party can itself be grounds to challenge an umpire's neutrality, separate from anything about the loss itself. Diagnosis, a genuine process problem, an undisclosed pattern of repeat selection affecting the umpire's neutrality. A motion to disqualify the umpire and compel a neutral selection process was filed and granted, and the panel proceeded with a replacement umpire. The lesson: when the objection is about who is deciding rather than what they decide, the correct response is a procedural challenge, not an argument about the dollar figure. Analysis: 3 invocations, 3 different causes. 3 homeowners were told their carrier had invoked appraisal and reached the same conclusion. This was a maneuver to avoid paying. Only one of the 3 actually reflected a problem with the process, not because the other 2 homeowners' suspicion wasn't understandable, but because they diagnosed the invocation before they understood what it was actually being used to resolve. Applying the wrong response in any of the 3 would have produced a worse outcome, resisting a legitimate, policy-provided process for resolving a genuine valuation gap, allowing an unresolved coverage question to be smuggled into a process with no authority to decide it, or accepting a panel's figure without ever questioning whether the panel itself was neutral. The trap isn't appraisal being invoked. The trap is assuming every invocation serves the same purpose. Some are the process working exactly as designed. Some are a coverage question wearing a valuation dispute's clothing, and some involve a panel that was never neutral to begin with. Until that distinction is made, it is impossible to know whether the right response is to participate, to object on the merits, or to challenge the process itself. Clinical Pearl: appraisal settles a number. It does not settle a dispute. Homeowner names, adjusters, carriers, and claim specifics in this report are composite and fictional, constructed for illustrative and educational purposes. They do not describe any actual individual, insurer, or pending matter. This report does not constitute legal or insurance advice. Appraisal clause language and applicable procedural rules vary by policy and by state. A homeowner facing an appraisal invocation should review their specific policy language and consult a licensed attorney where a coverage or process question is in dispute.